The Representative Actions for the Protection of the Collective Interests of Consumers Act, a somewhat unwieldy title to the legislation, was signed into law in July, but has yet to be brought into operation. The Act brings about a significant change for litigation in Ireland. In Ireland at the moment, unlike in certain other jurisdictions such as the US, class actions can't be brought. The Irish court rules do allow for certain types of representative actions, but those are limited in scope and are rarely used. Because of that, to enforce their rights, at the moment, consumers need to bring individual actions, which can be time-consuming and costly. The Act changes this and will allow so-called qualified entities to bring representative actions on behalf of consumers, but only in respect of breaches of certain specified consumer legislation. It won't introduce representative actions generally. The Act will allow representative actions to be brought under a wide range of consumer protection legislation based on EU directives and regulations. This includes, but is not limited to, GDPR, the Liability for Defective Products Directive, the Sales of Goods Directive, and the General Product Safety Directive. So the Act will affect businesses across a wide variety of sectors. The Act allows so-called qualified entities to bring representative actions on behalf of consumers. To become a qualified entity, bodies will have to apply for designation to the Minister for Enterprise, Trade and Employment, and will have to meet certain criteria, including that they're non-profit in nature and that they can demonstrate at least 12 months activity in the consumer protection space. Therefore, private law firms won't be able to be designated as qualified entities, and it remains to be seen what types of bodies in Ireland will be designated as qualified entities. Qualified entities will be able to seek injunctions and other forms of redress measures, including damages. Where damages are being sought, consumers will have to opt into the representative action, although they won't have to opt in if injunctions only are being sought. Qualified entities from other EU member states will also be able to join forces with Irish qualified entities to bring cross-border representative actions. The qualified entity will have to fund the action, although it's likely that the loser pays principle will apply at the end of the case, whereby the losing party will have to pay the winning party's costs. There are some question marks over how representative actions will be funded, given the continued prohibition on third-party litigation funding in Ireland, although this is an area of the law that the Law Reform Commission is currently looking at, so we might see change in this area in the future. The Act is a significant change for litigation in Ireland and for any businesses that deal with consumers, so those businesses should start to familiarise themselves with the Act. If you're interested in learning more about the Act, do feel free to reach out to us.